Merci. Nous allons passer au point 4. Continuer du moins le point 4 sur l'organisation des panels. Là, nous avons un panel sur les exécutions extrajudiciaires en Afrique. L'état des lieux et quels sont les défis, est-ce qu'il y a des progrès, est-ce qu'il y a des recommandations, est-ce qu'il y a des États aussi qui se sont fait remarquer par leurs bonnes pratiques. Nous allons donc pour ce panel-là passer la parole à la présidente du groupe de travail sur la peine de mort, les exécutions extrajudiciaires en Afrique, la commissaire Kaitesi. Merci.
Bon après-midi tout le monde. Honorable Chairperson, distinguished participants, all protocols duly observed. This panel will discuss on the question of extrajudicial killings. As you know, extrajudicial or arbitrary killings continue to present a major challenge in terms of protecting the right to life in Africa, and is manifested in many forms. Many people have lost their lives or are at a high risk of losing their lives because of excessive use of force by security agents, domestic violence, armed conflict, ritual, or other killings, to name a few. All these situations present a unique challenge that should be addressed as a matter of urgency. Various independent research conducted in a number of African states strongly suggest that excessive use of force, armed conflict, domestic violence, custodial death are a significant threat to the lives of many in Africa. However, in many African states, statistical reporting on homicide appear to make comparative research difficult. This is as a result of the weaknesses of national prevention systems and the poor quality of data, which constitutes major barriers in preventing these unlawful killings and developing meaningful prevention strategies. As a result, the lived realities of many Africans who are victims of extrajudicial killings die silently and unnoticed from the hands of the perpetrators within the homes and the communities, thus violating the fundamental right to life. Most of these victims have no voices and no opportunity to get the issue brought to the fore for action. The main objective for this panel discussion, therefore, is to raise awareness on the question of extrajudicial killings in Africa, the challenges and the way forward in ensuring a better protection of the right to life as provided in the African Charter. Honorable Chairperson, distinguished participants, we have 3 panelists this afternoon to deliberate on this important question. The first panelist is Honorable Commissioner Lumbu, who will give us a short presentation on the work of the Commission regarding this issue with a focus on some of key cases strengths since 2016 and recommendations made in this regard. We have a second panelist who will touch on the meaning and the scope of extrajudicial killings under international law and the strategies to ensure better protection at the national level. And last but not least, the third presenter, who will discuss on the issue of extrajudicial killings with a specific focus on Kenya. The second panelist is Dr. Toma, and the third is Madame Anne. And to start, I would like to give the floor to Commissioner Lumbu for this a brief presentation. Commissioner, you have the floor.
Merci beaucoup, Madame la commissaire Kaitesi, présidente du groupe de travail, Madame la présidente de la Commission africaine des droits de l'homme et des peuples, Mesdames et Messieurs les commissaires, chers délégués des États parties, distingués participants, c'est pour moi un honneur de prendre part à cette activité de cet après-midi, à ce débat très important sur la question des exécutions sommaires et extrajudiciaires en Afrique, en ma qualité de membre du groupe de travail sur cette question. Ce qu'il faut retenir, c'est que depuis la création de ce groupe de travail en 2012, et ces exécutions sont documentées, comme vous le savez. L'une des missions du groupe de travail est de documenter les exécutions. Elles sont documentées et le groupe de travail a maintenu un dialogue avec les États parties à la charte pour que ceux-ci puissent prendre des actions préventives afin que ces exécutions ne puissent plus avoir lieu en Afrique. Des informations sont consignées dans les rapports. Toutes les informations que nous documentons à travers le dialogue ou à travers les cas qui nous parviennent sont documentées dans des rapports d'intercession de la présidente du groupe. Il suffit d'aller chercher dans ces rapports, elle s'y retrouve. Et il figure également dans les rapports que la présidente de la Commission africaine des droits de l'homme et des peuples, Madame Maïga, adresse aux organes politiques de l'Union africaine. Alors, il y a quelques cas, juste quelques cas, que nous pouvons épingler pour attirer l'attention des participants qui sont dans la salle. Donc, on va citer quelques pays où on a pu relever quelques cas. C'est ainsi qu'au Sud-Soudan, en 2016, une centaine de cas de disparition, de violences sexuelles, de recrutements forcés ont été relevés. Des travailleurs humanitaires ont été attaqués et tués parce qu'ils étaient pris en embuscade en mars 2017. Au Nigeria, plus de 300 personnes avaient été tuées à Zaria, dans l'État de Kaduna, en décembre 2016. Dans le village de Makurdi, 70 cas avaient été répertoriés. En ce qui concerne l'Égypte, nous pouvons citer le cas, le décès d'un homme à Luxor, un autre à Ismaïlia, ce qui avait d'ailleurs occasionné l'arrestation de plusieurs officiers en novembre 2017. On peut signaler également le cas de 44 personnes tuées en avril 2017. Vous le connaissez très bien, la situation des églises coptes. Au Burundi, la crise politique au Burundi a produit 474 personnes et 36 cas de disparition forcée, 374 personnes tuées. Particulièrement, nous relevons le cas de l'ancien ministre Emmanuel Nyonkuru, qui avait été tué le 1er janvier 2017. Au début, j'ai parlé du Sud-Soudan, mais au Soudan aussi, en 2016, 200 personnes sont décédées suite à des attaques chimiques. En Gambie, Nous pouvons signaler le cas de Solo Sandeng et de Solo Kuruma en avril 2016 à Kuruma. En avril 2016 à Kuruma. Il y a également en Éthiopie la crise de Oromia qui a créé des centaines de morts et des cas de déportés. Au Kenya, précisément à Nyanza, plusieurs cas de brutalité policière ont été relevés, 24 personnes tuées et une centaine d'autres blessées. Il y a des cas d'autres pays qui existent mais qui n'ont pas été répertoriés. Ici, c'est juste un échantillon que nous donnons. Voilà, Madame la Présidente de la Commission, Madame la Présidente du groupe de travail, voilà brossé très rapidement, parce qu'on a très peu de temps, que 5 minutes, brossé très rapidement un état de lieu de la situation sur cette question. Je pouvais également donner les recommandations que nous avions formulées dans le groupe de travail, mais je pense que je vais les garder pour qu'à la fin, lorsque nous allons avoir le débat, nous puissions rappeler quelques-unes des recommandations. Je vous remercie.
Merci, commissaire Lumbu, pour cette information par rapport à la situation des exécutions extrajudiciaires. Le deuxième panéliste, c'est Dr. Thomas Probert. Is the head of research of an initiative called the Freedom from Violence at the Center for Human Rights, University of Pretoria. He has worked for the last 5 years with the former UN Special Rapporteur on extrajudicial and the unlawful killings, Professor Christoph Hens, and is also a researcher at the University of Cambridge in the UK. You have the floor, Dr. Thomas.
Thank you very much, Madam Chair, and it's a great pleasure to be back here at the Commission and talking about these very important subjects, to have seen the Commission's thinking about the mandate of this working group evolving over the last 5 years, as you say, and in fact, even longer than that. It's marvelous to see this panel taking place in front of plenary. To begin with, just a word about the word extrajudicial. I'm reminded when I was thinking about what I was going to say today of the remark that former Special Rapporteur Philip Alston made to then the Commission on Human Rights about how the 3 words that constituted the name of his mandate, the UN mandate being the same as the mandate of the working group here, that the words extrajudicial, summary, or arbitrary, trying to decide whether a killing is one of those 3 things is not really the best way to understand the mandate, and that, in fact, the mandate represented the decision of the Commission to review all killings that are unlawful under international law, and therefore arbitrary. So the focus at the normative level, I think, is very much the right to life. Pronounced in the first instance in Article 3 of the UDHR, the 70th anniversary of which we've been celebrating during this session, and then elaborated in a little more detail in Article 6 of the ACHPR and Article 4 of the African Charter. In both of those latter cases, the clear prescription being on the arbitrary deprivation of life. So within those 3 core human rights foundational documents and the broader corpus of international law, I think we have an understanding that the prohibition of arbitrary deprivation of life is a supreme foundation, sometimes called foundational human right. It's a non-derogable right. You cannot decide that because of a state of emergency or for other reasons, the right can be derogated from. And it is a right that, at least in its core content, has been argued to meet the status of jus cogens. However, it's not an absolute right. There are circumstances in which it may be lawful under international human rights law that the state deprives someone of of life. And the devil, as always, is in the detail. The definition, therefore, of what an arbitrary deprivation of life needs to be found in a number of ancillary human rights documents, and there are many, both at the UN and at the African Commission level. To begin with, the documents surrounding the death penalty, for example, the ACHPR provides some of the limitations within the text of Article 6, but they're further elaborated in documents such as the safeguards guaranteeing the rights of those facing the death penalty from 1984. There are then a number of documents related to the use of force by law enforcement officials, the Code of Conduct from 1979, the UN Basic Principles on the Use of Force and Firearms from 1990, and then a number of broader documents that particularly focus on the question of investigations, because as I think we'll see, the need to be able effectively to investigate an allegation of an unlawful killing is really central to any strategy aimed at reducing their incidence. And so we have the UN Principles on the Prevention and Investigation of Extra-Legal, Arbitrary or Summary Executions, usually just called the UN Principles of 1989, and the Minnesota Protocol, which was a more practical manual aimed at implementing those principles that was published by the UN 2 years later in 1991, and which has very recently been updated by now former Special Rapporteur Christoph Haynes in a process that lasted a number of years, but which has produced a document published by the UN in 2017, and that is in the process of being translated into French. It's already been published by the UN in Spanish. The French version is on the way. At the African Commission level, the core document really in understanding the right to life is the African Commission's General Comment on the Right to Life, General Comment number 3. The lights come on just in time for you to see it. And most of the language that I will describe to you today will be taken from that general comment. But there are also more specific documents, for example, the Luanda guidelines on conditions of pretrial detention that I think are very helpful in understanding the concept of custodial death that, Madam Chair, you mentioned in your opening remarks. And even more recently, the guidelines on policing assembly by law enforcement officials in Africa. So all of these documents provide technical understandings of circumstances in which a particular death would be arbitrary, but General Comment number 3 provides a more general definition as well. So a deprivation of life, in the words of paragraph 12 of the General Comment, a deprivation of life is arbitrary if it is impermissible under international law, those other documents I've talked about, or under a more protective domestic law provision. And arbitrariness should be interpreted with reference to considerations such as appropriateness, justice, predictability, reasonableness, necessity, and proportionality. Any deprivation of life resulting from a violation of the procedural or substantive safeguards of the African Charter, including on the basis of discriminatory grounds or practices, is arbitrary and as a result unlawful. However, as I intimated earlier on, I think the challenge of confronting unlawful killings in Africa and around the world often tends to be a problem of fact rather than a problem of norm. And it's for that reason that investigations are so important, and why it is important to ensure that domestic level legislation conforms with the norms that are so well agreed at the international level. Generally speaking, the response of the plaintiff, the state, in response to an allegation of an unlawful killing will be one of two things. Either it didn't happen, or it was nothing to do with us, or it happened, but it was lawful under national law. Those two responses are the usual responses to an allegation of unlawful killing, and they provide different challenges to those working around these issues. So to address the first category first, these are probably what people think of as classic extrajudicial executions, deliberate, secret, purposive acts to kill a political opponent, a critic of the government, a human rights defender, or indeed anyone else. These usually occur in secret and may subsequently become public. So in many cases, at least to begin with, you won't have the body of the victim. The body may subsequently become public, or in some particularly gruesome cases, it may deliberately be made public as a warning to others, or as an act of negligence on the part of those responsible, or as a result of a feeling of security in a climate of complete impunity that the perpetrators are so confident that they will get away with this act that they leave the body for all to see. So the challenge here is not to establish whether the killing was unlawful. It usually manifestly is unlawful under even national law. Rather, the challenge is to establish that the state was connected with the act. And this is a challenge often of forensic evidence to link the perpetrator to the act and to link the perpetrator to the state. But it can also rely upon other forms of evidence, witness statements, documentary evidence of how orders were passed from official to actor, etc. So, in terms of legal or advocacy responses to such an event, one clearly has the obvious charge of murder, or in the human rights law, an allegation of a violation of Article 4 of the Charter. But I suggest there are also two other important considerations that we should bear in mind when confronting this kind of killing. The first is the failure to investigate. And this was the essence of the Zongo decision of the African Court, which found a violation of Article 7 rather than a violation of Article 4. But I think it is also important to highlight that in addition to being a violation of Article 7, a failure to investigate a potentially unlawful death is a violation of Article 4. It is a violation of the right to life, as the Commission says in its general comment. The failure of the state transparently to take all necessary measures to investigate suspicious deaths and all killings by state agents and to identify and hold accountable individuals or groups responsible will amount in itself to a violation by the state of that right, of the right to life. And then the other core strategy that might be pursued is a failure to protect. In many cases, the killing of a prominent human rights defender or journalist will be preceded by a number of indirect or increasingly direct threats against that person. And so the disappearance or death of that individual, even before the evidentiary requirements of establishing his or her murder can be established, there is a clear failure of the state to protect from those very direct threats. And again, there's language in the general comment about the state's responsibility to protect in the event of threats. Then briefly to describe the second broad category of these killings, those that the state does not deny that the killing took place. They often take place in plain view, but that they assert that they are lawful under national law. These most frequently are deaths involving the police or other law enforcement officials, about which I'll say a little bit more later. They may be a violation occurring in the course of an armed conflict, because, as we know, the right to life continues to apply during armed conflict. It may be the imposition of a death sentence on arbitrary grounds. There may be, as the Commissioner highlighted, custodial deaths occurring where the state exercises heightened control. Or they may be forms of what in its intercession reports the working group refers to as private killings, acts perpetrated by non-state actors, but which form a systemic pattern that is observable and therefore arguably preventable, and that can thus incur the responsibility of the state. So as I said, I'm going to focus briefly for reasons of time on the first, deaths caused by law enforcement officials. And again, the Commission has elaborated very clear standards on the use of force by the police. There are the 5 core principles of legality, precaution, necessity and proportionality, and accountability. However, national legislation on the same subject is often inadequate. In many cases, antiquated legislation remains on the books in many countries around the world. The existence of vague laws that allow for the use of potentially lethal force to protect property, broad immunities for law enforcement officials, or allowing the use of lethal force against a fleeing criminal subject are all things that we find within examples of national legislation on these subjects. And the existence of this permissive legal environment, in combination with obviously other factors such as police training, law enforcement equipment, have a profound impact on the number of deaths that occur that under international law would be unlawful. And they also pose significant challenges in pursuing accountability for those deaths because under national law, they were legal. And so to make a recommendation in terms of the work of the Commission, my contention would be that involving the scrutiny of such laws as part of the state review under Article 4 of the Charter, including requiring that states report on such laws and engage with the limitations of such laws during interactive dialogues, would make a profound step forward in terms of the protection of the right to life on the continent. And then, in conclusion, to make a brief plug for a project that goes some way to achieving this already, which is a project run out of the University of Pretoria, a website called policinglaw.info, which brings together national legislation and case law regarding the use of force, hopefully as a basis for engagement, research, review, and reform. So far, we've done 61 countries. Our objective is to do all of the countries in the world by the end of next year. But of those initial 61, 24 are currently in Africa, so there's a good chance that your country is already available on the site. And we certainly encourage you to go, perhaps for the first time, to review your national legislation. Let us know if we've missed anything, but to take note of comments that are made in terms of how that legislation conforms with international law. Thank you very much, Madam Chair.
Merci, Dr. Thomas, pour cet exposé qui nous a fait état de la question des exécutions extrajudiciaires dans le contexte du droit international et dans le contexte du cadre légal régional. La troisième panéliste, c'est Madame Anne Mulama. She is an advocate of High Court of Kenya and a legal officer at Independent Medical Legal Unit, an NGO based in Nairobi, Kenya. And for over 25 years, IMLO, this NGO, has worked to support victims of state-sanctioned torture, violence, and discrimination, document cases of extrajudicial killings, as well as intervene through the provision of medical services, psycho-social support, and litigation to victims. Elle va focaliser sur la question des exécutions extrajudiciaires, focalisant sur le cas du Kenya. Madame Anne, vous avez la parole.
Thank you, Madam Chair. As she has already mentioned, I will speak with specific reference to Kenya, but in certain instances, I'll be able to refer to other countries, especially with, by giving examples. And my basis of reference will be annual reports, for instance, Amnesty International, Human Rights Watch, and also the county reports on human rights practices, as well as reports that have been formulated and also shared by various national government organizations that deal or work around this subject. Much has been said by the other panelists, so I will speak briefly about the statistics and in specific reference to Kenya. I'll also give you the various trends in regards to extrajudicial killings, and I will also give you some of the root causes of extrajudicial killings, and lastly, I'll wind up by giving various recommendations that we've been able to formulate as a result of various meetings that we've had with organizations and institutions that work to curb the vice. To start us off, I would like to begin by stating that the status of extrajudicial killing in most of the African countries is alarming. Specific reference to the Kenya, in 2013, our organization, the Independent Medical Legal Unit, carried out a study on deaths from firearms covering a 5-year period, 2009 to 2013, and produced a report titled Guns, Our Security, Our Dilemma. The study covered 1,873 post-mortem reports of gun-related deaths from 7 government mortuaries. And at the end of the study, the findings showed that 67%, which is equivalent to 1,252, were by law enforcement agents, followed by robbers and thugs, and undetermined group of 13% and 17% of cases respectively. Further to that, our organization has been able to document 853 cases of extrajudicial executions between the year 2013 to September 2018. And according again to Amnesty International report that was produced just the other day, 2017-2018 period, there is a confirmation of an increase of cases of extrajudicial killings in countries like South Sudan, Burundi, Rwanda, Cameroon, Togo, and DR Congo, just to mention but a few. Extrajudicial killings, again, in Amnesty's report indicates that, as Probert has already said, in most of the African countries, they are often associated with government repression of opposition political parties and also denial of freedom of speech. In respect to who are the victims of these kind of violations, the victims include human rights defenders, religious actors, political activists, journalists, and in some cases, people who have dissenting opinion to the government. They also include criminal suspects, young men from poor socio-economic backgrounds, and Muslims with alleged links to the terror groups. Especially special attention and focus is in Mombasa, whereby they deal with counterterrorism and also organized criminal gangs. In regards to the perpetrators of this violation, they are drawn from states' security sector. They're usually the police and various formations within the police, such as counterterrorism unit, the military, and also military intelligence and other groups who commit violation of this extrajudicial killing at the behest or get blessings from the state for them to be considered in this group. I'll just go straight into the trends, and already some of the panelists have already shared, so I'll just speak to those that have not been touched yet. The trends include 1, unlawful killing during mass demonstration. Commissioner Lumbe has already touched about the Kenyan situation. For instance, the Nyanza, during electioneering period, we see massive deaths, and these come as a result the police trying to quell and provide calmness. They end up killing so many people. And in some instances, however, the perpetrators also include anti-government activists, militia, and vigilante group. I'll speak, the next one include unlawful killings during counterterrorism and security. I've already stated this reference in Kenya. For instance, Haki Africa is a leading organization situated in Mombasa in Kenya. It has been able to document 78 extrajudicial execution in an effort to fight the insurgent Al-Shabaab terror group. The police and other investigating officers have turned a blind eye to the human rights, and at the end, so many people have suffered and are killed as a result of that. And also, according to Amnesty International report again, majority of the extrajudicial execution cases happened in the context of counter-terrorism operation targeting the terror groups. There is another trend of which involved unlawful killing of human rights defenders. The number of killing of human rights defenders by state security remains truly shocking. According to a report titled Annual Report on the Human Rights Defender at Risk 2017, which was compiled by Frontline Defenders, it shows that 312 murders were documented in 27 counties, and 80% of the 312 deceased human rights defenders had previously received a threat and reported the same to the authorities for investigation to be done and protection given. However, no preventive action was taken by the police at an early stage to reduce the attacks against the HRD. At the end, it led to various violations of the human rights. In Kenya also, as you're all aware, most of you, I guess, there was the case in point involves the killing of the human rights defender Willie Kimani, his client Joseph Mwendwa, and their taxi driver Joseph Muri, who were abducted and later found dead in a river. This shows that the situation in regards to extrajudicial linking with the human rights defender continues to be an issue in Kenya also. Unlawful killing in a shootout with armed robbers is yet another trend in regards to extrajudicial killing, whereby the security agents have often claimed the most of the victims were armed robbers who ended up being shot dead in a shootout, quote unquote, with police. Despite the fact that in some cases the police have encountered with real armed robbers, we are alive to the fact that in many of those occasions the police unnecessarily used force. For instance, in 2006, the UN Special Rapporteur on Extrajudicial Killings visited Nigeria and stated that the label of armed robber is often used to justify the jailing and or extrajudicial execution of many innocent individuals. In yet another report, fact-finding mission done in Kenya by UN Special Rapporteur Philip Alston, he reaffirmed that many unlawful killings are done by police in the name of crime control, but in circumstances where they could readily make an arrest. I'll go straight into, because I see the other trends have already been handled, I'll go straight into the root causes of extrajudicial killings. One, it involves existence of repressive regimes that use the police as forces of oppression and allow them to use excessive and lethal force with minimal or no accountability. An example of this would be Special Rapporteur's report on Gambia in 2015, whereby they stated a repressive state apparatus in the hands of the security forces appears to reign in Gambia. There is a widespread fear in civil society about the unchecked use of force by law enforcement agency. The security forces, over which the president retains a strong grip, actively repress any signs of discontent, terrorizing civil society and instilling a climate of fear and mistrust via routine arrest. The next root cause include a lack of operational independence and professionalism within the policing agency, mainly due to political control of the police by the regimes in power. Police in instances are instrumental to meet certain political goals of those in power. For instance, in Kenya, the Kenyan election, post-election violence 2007-2008, and as well the 2017 general election, whereby we also so massive loss of life. Then the next root cause is lack of inadequate policy and legal guidelines on restraints on police use of force or lethal force. Though Kenya has a robust legal, regulatory, and policy provisions, amendment to the NPS, National Police Service Act 2011 in the Miscellaneous Law Amendment Act 2015, which provided for police to now use lethal force to protect property in violation of the African Charter, the ACHPR and UDHR has already been mentioned. Such backtracking is not unique to Kenya, especially with the rising challenge of terrorism and organized crime, where states under pressure are increasingly resulting to tough on crime measures that violate human rights and fundamental freedom that are great threat to the right of human life, human dignity, and the right to freedom. Then there's another root cause of extrajudicial killing, which is the normalization of extrajudicial killing by communities who suffer robberies without requisite support by the law enforcement officers and criminal agencies. Case in point is in Kenya. There's a case, criminal number 78 of 2014, Republic versus Titus Ngamau, alias Kaititu, whereby a police officer was found liable of murder and was sentenced to 15 years imprisonment. We could see on the news, in the news, and there were demonstrations to release, to demand the release of this police officer, mainly people saying that this is the police officer who was helping them to fight the thugs. So this is yet another trend that is cropping up of normalizing extrajudicial killing by the citizens of various states. Then there's also lack of inadequate forensic capacity for gathering, storage, analysis, and use of medical legal evidence in holding perpetrators to account and redress for victims and their family. There's also failure of adequate investigation depth. Thomas has already touched on that, and also lack or weak of oversight policing mechanisms. Then in terms of way forward for Africa, again, recommendation has been made here and there, then I will be able to speak on those that have not been mentioned yet. One of the recommendation would be to ensure command responsibility and accountability for senior officers that are involved in or under whose command junior officers commit extrajudicial killings and enforce disappearance, and further ensure all security officers directly involved in extrajudicial killings and enforced disappearance are held to account both administratively and criminally. Then should speak to ensure that redress and rehabilitation measures are put in place to alleviate the plight of victims through enactment and implementation of various laws and procedures. Then to establish and or enhance the existing witness protection agency and programs, especially as Thomas has already hinted to the fact that documentation is also one of the key issues that help in access to justice. So whereby in some cases you find that witnesses to extrajudicial killings face threats from the perpetrators, this enhancing of the protection mechanism would go a great way in fighting for justice. Then the next recommendation would be to establish or strengthen the independent policing civilian oversight bodies. Then enhance forensic capacity by establishing strong and independent coroner services in various states. Then last but not least, I would urge the working group to establish a structured collaboration with civil society organizations who have observer status at the African Commission. This is in order to gather information and publish a comprehensive status report on extrajudicial, summary, and arbitrary killings in Africa, which ideally will go a long way in order to address this subject. Thank you so much.
Merci, Madame Anne, pour cet exposé. détaillé qui nous a donné assez d'informations par rapport à cette question qui touche le droit à la vie et pour les recommandations. Alors, sans tarder, je voulais donner la parole à l'audience pour votre contribution en ce qui concerne les mesures à prendre pour adresser cette question des exécutions extrajudiciaires.
إن حكومة السودان تبدي أسفها وقلقها لما أورده تقرير المفوض المختص، وهو يمثل لبعض حالات القتل خارج نطاق القضاء، حيث أورد أن هناك 200 شخص قد قتلوا في السودان بهجوم كيماوي. ونحن نقول أن هذه الادعاءات سبق وأن تمت إثارتها أو إيرادها في بعض تقارير المنظمات في العام 2016، حيث أوردت أن هناك استخدام لأسلحة كيماوية في دارفور، وشكلت البعثة المشتركة للأمم المتحدة والاتحاد الأفريقي في دارفور يوناميد لجنة فنية مختصة للتقصي والتحقق من هذا الادعاء. وقد خلصت اللجنة إلى عدم وجود أي آثار لاستخدام أسلحة كيماوية أو ضحايا لأسلحة كيماوية مزعومون في تلك المنطقة. وقد أصدرت اليوناميد البعثة المشتركة بيانا في هذا الصدد. إن الاستشهاد بهذا الادعاء كمثال لحالات القتل خارج نطاق القانون نعتبره استشهادا في غير محله وغير موفق، ونحن نأسف أن يتضمن التقرير معلومات غير صحيحة، ونحن نأسف أن يتضمن التقرير معلومات غير صحيحة وإيرادها في مستند رسمي خاص باللجنة الأفريقية لحقوق الإنسان والشعوب. شكرا جزيلا.
My name is Benny Gideon, NRI South Sudan. Mine will just be a recommendation. I applaud the presentation and the content of the report. However, what I would just want to add as my recommendation is the protection mechanism for the human rights defenders in the AU member state, and particularly those that are in the situation of armed conflict. As NRIs, it's a matter of procedure that at the NRI's institution we have what is called human rights defenders desk, and this human rights defenders desk is important, has a quick response mechanism for the protection of the work of the human rights defenders, so that if they fall into trouble with the state security apparatus, the nearest institution they can report to is this desk, so that the desk can take the matter and recommend appropriate action. It is equally important that the AU member state need to be reminded on their primary obligation on the responsibility to protect, and that the primary obligation of the responsibility to protect is enshrined both in the respective country's constitution as well as regional and international obligation. And not only that, this question of sovereignty should not be allowed as a barricade for member states to do impunity or act with impunity and expect to get away with it, because the primary responsibility is associated with cost. Because failure to discharge your primary responsibility to protect, then that responsibility automatically shifts from the state to the other level, and this includes individual criminal responsibility, because there has been ongoing condonings of impunity because of lack of accountability, because some state provided immunity, state protection to this individual, and this must be clearly underlined by the Commission, that crimes such as imposed disappearance are individual criminal responsibility. Extrajudicial killing are individual criminal responsibility. Thank you very much. That is the recommendation I need to put across.
Merci. Bonjour Madame la Présidente, Messieurs les membres du panel. Je voudrais attirer l'attention sur les exécutions extrajudiciaires très graves en Mauritanie de 89 à 91, dont 506 militaires ont été tués, dont 28 sont exécutés le jour de l'indépendance de la Mauritanie, le 28 novembre 1992. Ce dossier n'a jamais été réglé, malgré qu'il y a la résolution d'Alger en 2009, suite à une plainte qui a été déposée par le comité de solidarité avec les victimes de la répression dont je suis membre durant la session en 1993. Aujourd'hui, les veuves et les ayants droit exigent, malgré qu'une aide a été donnée par le gouvernement mauritanien et que nous apprécions, mais aucun autre règlement en dehors de cette aide qui a été donnée à 2 heures du matin avec la signature d'un document qu'on ignore jusqu'à présent le contenu. C'était à 2 heures du matin. Aujourd'hui, la question de ces exécutions extrajudiciaires pose problème. Nous demandons à la Mauritanie et nous sollicitons qu'une commission de vérité et réconciliation soit mise sur place pour élucider ces exécutions extrajudiciaires et chercher à mettre la lumière sur la question, sur ce qui se passe en Mauritanie. Sinon, la Mauritanie, l'existence, la cohésion sociale, la stabilité est menacée par le nombre de problèmes qui se posent aujourd'hui, des exécutions, des fausses communes, du racisme, de l'exclusion. Nous demandons à la Commission et aux reporters chargés des exécutions extrajudiciaires et des disparitions forcées d'élucider ce problème, parce que ces gens sont des musulmans. Jusqu'à présent, aucun corps n'a été retrouvé et aucune solution n'a été aussi retrouvée. Je vous remercie.
Madame la Présidente, je prends la parole pour rappeler très brièvement le sort qui a été réservé à notre collègue Feu Chebeya Floribert, qui avait été sauvagement achevé par étouffement dans le bureau de l'inspecteur général de la police nationale de la RDC. Les faits se sont déroulés à Kinshasa dans la nuit du 1er au 2 juin 2010, et à ce jour, il n'y a pas le moindre frémissement de la part de la Commission africaine des droits de l'homme et des peuples, ni de la part du Conseil des droits de l'homme, pour mettre en lumière les responsabilités sur lesquelles il n'existe aucun mystère. John Numbi, le général John Numbi, a été désigné comme l'exécuteur principal dans cette tragédie. Donc j'appelle au nom du bon sens, de la conscience universelle et des droits de l'homme, l'attention de la Commission sur la nécessité de mettre en lumière tout ce qui s'est passé là. Le deuxième point et le dernier que je voudrais, sur lequel j'appelle l'attention de la Commission des droits de l'homme et des peuples, la Commission africaine des droits de l'homme et des peuples, c'est les exécutions extrajudiciaires au Kasaï. Des images existent, des vidéos existent. Les massacres du Kasaï ont secoué l'opinion mondiale l'année dernière, jusqu'à cette année encore, et il n'y a pas la moindre avancée dans les enquêtes qui avaient été promises par le gouvernement congolais. Zaïda Catalan et Michael Sharp, 2 experts envoyés par les Nations Unies pour enquêter sur les massacres du Kasaï, ont été achevés à la mitraillette. Les vidéos existent, des indices plus que probants, pointent du doigt le gouvernement, les autorités congolaises, donc le régime Kabila. Et à ce jour, tout se passe comme dans le meilleur des mondes. Rien n'a été fait, rien ne s'est passé. C'est les intérêts économiques qui prévalent. Madame la Présidente, vraiment, faites quelque chose pour que les gens ne regrettent pas d'être venus sur Terre pour n'être que témoins de massacres, de fausses communes et de privation de droits. Puissent aider les peuples qui en ont le plus besoin de faire entendre raison à l'opinion mondiale et de faire raison à leurs droits. Merci infiniment, Madame la Présidente.
And I would, in response to that, I'll just urge the working group to urge the states, various states that we've been able to see even during the reporting that the issue of extrajudicial killing continues to occur. The states should be able to issue a standing invitation to conduct country visit in order to appreciate what is the depth of extrajudicial killings in most of the African countries. Thank you.
Thank you, Madam Chair. I think just three issues that I'd respond to. The first raised from the delegate from Mauritania around the delay to an investigation. The general comment makes clear that one of the expectations about investigations into potentially unlawful deaths is that they be prompt, but although the general comment doesn't make it clear, the Minnesota Protocol does make clear that that doesn't mean that in events where the violations potentially occurred some time ago, the obligation to investigate expires somehow. The duty to investigate past grave human rights violations continues, and many of the same standards apply. Secondly, the point that was raised by the National Human Rights Institution of South Sudan around general immunity provisions, I naturally completely agree that it's important to maintain individual criminal responsibility for acts perpetrated in violation of the right to life, but I would also highlight that the very existence of such an immunity provision is itself a violation by in an arbitrary way foreclosing accountability for such acts. The law is in violation of the Charter. And then thirdly, to pick up from the idea of duty to protect, to point out, and in a way to segue with perhaps the coming panel on the rights of persons with albinism, the extent to which the general comment broadens out that duty to protect. So I mentioned earlier the language on duty to protect against direct threats, but paragraph 39 of the general comment also says that the state is responsible for killings by private individuals which are not adequately prevented, investigated, or prosecuted by the authorities, and those responsibilities are heightened when an observable pattern has been overlooked or ignored. And I think that speaks to many of the concerns that are often raised in front of the Commission in other panels as human rights violations in themselves, but that when they amount to threats to life or indeed result in loss of life, they are also potentially violations of the right to life. Thank you.
Merci Madame la Présidente. La première recommandation que je souhaiterais en tant que membre de ce groupe de travail, c'est de demander d'abord aux États, parce que comme je l'ai toujours dit, les premiers défenseurs des droits de l'homme, c'est d'abord les gouvernements, donc les États. Et la première recommandation, c'est leur demander de respecter urbi et orbi le droit à la vie, parce que sans vie, les autres droits de l'homme ne peuvent pas exister et ne peuvent pas être protégés. La deuxième recommandation, c'est celle de demander aux États, c'est un appel que je lance par rapport aux mesures qu'ils doivent nécessairement prendre pour éviter que les exécutions extrajudiciaires sommaires et arbitraires puissent avoir lieu. Mais lorsque quand même ces exécutions ont lieu, il faut que les États, de manière tout à fait proactive, puissent initier des enquêtes rapides et effectives pour faire face aux allégations de violation des droits à la vie, faire face aux allégations de violation des droits de l'homme et traduire s'il est chez les responsables de ces violations en justice. Ensuite, en troisième lieu, ils doivent également prendre des mesures préventives pour pour combattre partout où cela se pose des exécutions extrajudiciaires qui sont faites dans le cadre de la lutte contre le terrorisme, parce que comme vous le savez, la lutte contre le terrorisme est devenue un fourre-tout. On tue partout, même pour des vols, des petites choses, on qualifie les gens de terroristes et on les assassine. Ensuite, la dernière recommandation, et je la tire de l'INDH du Sud-Soudan tout à l'heure, peut-être qu'il s'avérera nécessaire d'avoir au plan national des mécanismes un peu indépendants, en dehors des États qui sont eux-mêmes les premiers protecteurs des défenseurs des droits de l'homme et des autres, mécanismes de protection des défenseurs des droits de l'homme dans les États partis, surtout des États qui sont en proie à des conflits. Concernant les autres recommandations sur le Soudan et autres, je crois que vous êtes mieux placé pour pouvoir en parler. Voilà en quelques mots rapidement ce que je peux dire à ce stade du débat. Merci.
Merci les panélistes. À propos de ce sujet, en tant que président du groupe de travail sur les exécutions extrajudiciaires et sommaires, je pense que nous devons reconnaître que la question des exécutions extrajudiciaires dans nos pays est une question très compliquée, parce que implique les agents de sécurité, ou si ce n'est pas les agents de sécurité, ce sont les acteurs privés qui sont couverts par les agents de sécurité, ou bien ce sont les actes des privés tolérés par les agents de sécurité. Et ça fait que ça soit compliqué, de façon que au lieu de procéder aux enquêtes, les enquêtes qui doivent être faites par le gouvernement, il y a l'impunité. On laisse les acteurs impunis, ce qui, à la longue, implante la culture de l'impunité. Et nous tous, nous savons les conséquences de l'impunité, c'est-à-dire que ces actes vont continuer et à un certain moment, même l'État n'aura pas à contrôler les acteurs de ces actes de privation de la vie. Moi, je pense que, en répondant à la délégation du Soudan, que c'est vrai, vous pouvez dire qu'il n'y a pas eu de tels actes qui ont été perpétrés, mais la commission a été informée qu'il y a eu ces exécutions extrajudiciaires. À la même époque, on peut se souvenir aussi des cas du bombardement des civils dans la région du South Kordofan et du Blue Nile States. Tout ça, ça constitue des actes d'exécution extrajudiciaire. Et nous pensons que, au lieu de dire tout simplement qu'il n'y a pas eu ceci, plutôt nous devrions prendre des mesures pour investiguer ces actes, afin de prévenir de futurs similaires actes. Concernant les recommandations qui ont été formulées par la panéliste Anne, concernant la collaboration de la Commission africaine avec la société civile, la Commission est disposée, toujours la société civile, les institutions nationales sont les partenaires de la Commission. Nous attendons des informations de la part de ces organisations pour avoir une idée de la situation dans les États. Et aussi, nous attendons aussi qu'ils réagissent au niveau du pays en interpellant les États pour amorcer les enquêtes. Et ce que je voulais demander aussi aux États, pour aussi contribuer à la prévention et à la protection du droit à la vie, c'est d'autoriser la commission l'émission d'établissement des faits lorsqu'il y a de telles situations d'exécution extrajudiciaire. Donc, ce qui complique encore la tâche, même lorsque la commission veut faire une mission d'établissement des faits, les États n'octroient pas les autorisations pour permettre à la commission d'accéder au lieu où les actes ont été perpétrés. Donc, ce qui fait que même la contribution de la commission est difficile à donner dans de telles situations. Donc, pour finir, je voudrais rappeler à tout le monde que le droit à la vie, comme disait mon collègue commissaire Lumbu et comme les autres panélistes l'ont dit, c'est un droit fondamental. Nous devons le protéger tous. Merci, Madame la Présidente.